Thank you. I now recognize the Junior Minister for Trade. I'm sorry, for Culture.
To make my contribution to this very important bill before us today, which is the Police Amendment Bill 2024. Madam Speaker, I request your permission to read from documents from time to time during my contribution. I thank you. The Police Amendment Bill has been quite a bit of concern throughout our community, and it's not just today or from yesterday when it was presented and we started the debate, and we're continuing today, and then we will go into committee stage to make the final presentation of the act for it to be assented, etc., going through the process. It has been a concern in our community from the time it was launched and the time it was publicized. It was part of the campaign in 2023. You know, persons will say to you, you get in there, you can't pass that bill because this is what I am concerned about, this can't happen, etc., etc. But, Madam Speaker, what I want to assure our territory is that their fears and their concerns have not gone unnoticed. We do recognize the fear of the possibility of the violation of the human and constitutional rights, but I can assure the public that we will, in this Honourable House, we are just as concerned, and we will do everything possible to ensure there's a balance in safeguarding their human and constitutional rights and ensuring that criminals are justly dealt with. Now, this bill is an amendment to the Police Act, revised edition of 2013. So there's already existing a Police Act. There was one before, and then there was one revised in 2013. So these amendments that we're dealing with today relate to the Principal Act of 2013. It is a bill to make provision for enhanced investigative powers and procedures and related matters. We've heard from the debates earlier, and from my colleague to my right, Honourable Dawson, that this bill is twofold, in a sense, in my view. It is dealing with, and Honourable Leader of the Opposition had mentioned it in his contribution as well, that the bill is dealing with some deficiencies, as stated in the mutual evaluation report. And it is also going to be dealing with strengthening the laws that deal with policing in an effect to curtail the increased level of crime that is taking place in our community, and a very, very concerned level of the crime that is taking place in our community. The Honourable Whitley, Minister for Health and Social Development, mentioned the correlation between crime and tourism, and the fact that we cannot afford to have the continuation of increased crime at all levels, whether it's a burglary, it affects our tourism product, or whether it's a gun crime that's even more hideous, and it gives us a bad name in our community, and then visitors in the end of the day won't want to come and visit. So the bill, in a sense, addresses these two areas. And with the mutual evaluation report, we know about it, we've heard about it, and it's been publicized that it's very important for us to address the issues that came out of the mutual evaluation report. And like the COI, there were some recommendations that had to be addressed, and in this mutual evaluation report, there are some recommendations that have to be addressed, and they have to be addressed in an urgent manner. But recognizing the urgency of the need to address these things, we can't just do it. We have to do it in a serious manner, taking into consideration the rights of our citizens, the rights and the right way to do things when we're dealing with policing. And Madam Speaker, I would like to just mention that No, we didn't just come across this particular bill today. It has been articulated to us and presented to us as members of this House of Assembly in an informal session in the format of a symposium. And the symposium was on legislators' reform related to the Mutual Evaluation Report 2023. And this symposium was held on the 21st of November for the benefit of the members to understand exactly what this Mutual Evaluation Report pertains to, the things that we need to do. The presentations were made by all the experts in the area. And it just doesn't include the police. It includes the financial services sector, of course. It includes customs. So we had reports from all the areas of interest pertaining to this Mutual Evaluation Report. And I also mentioned the fact that, it helps to curtail the things that are in here, helps us to curtail the growth or the increase of the criminal activities that are taking place in our community. And it is our responsibility in this Honourable House to address all these areas. And we just can't, not just, because the fact of the matter is, in going back to saying in terms of the Mutual Evaluation Report, it's a threat to our financial services sector. And, the goalpost, as we heard it before, it's been said before, continues to move when we're dealing with the financial services sector. And this is one aspect. Every time we address a concern and we feel that we're now safe and we're on the right track according to the international agencies and their requirements of us to get these things in place, they move it, and now they come with the report recognizing the deficiencies in our systems, and we have to address them. And of course, again, I mentioned the tourism sector. But Madam Speaker, I will go, my presentation will deal with, and others have dealt with them before, but I too would like to just give for the record and state for the record my view on certain things as it pertains to the bill. And I will be looking at section 35B and C, and clauses 35B and 35C, clauses 35A through 38H, and I will end with clause 38M. Now, 35B and C, and the Principal Act, as I mentioned, has a section 35. But 35B and C were inserted because of the Mutual Evaluation Report. And this section in particular, according to the information that was shared with us during the symposium, addresses some of the deficiencies that were highlighted in the Mutual Evaluation Report. So the section 35B deals with witness statements. And in section 35B1, it basically states, and B1 through 5 deals with how you take statements, witness statements. And just to explain, 35B1 says a police officer may, in the course of a criminal investigation, interview witnesses and take witness statements in accordance with provisions of this Act. And then it also goes on to say that witness statements shall be recorded in a manner that ensures the accuracy and integrity of the evidence, including audio or video recording where possible. And it also states in 35B3, the Commissioner shall maintain a secure system for storage and retrieval of witness statements. So basically what this bill is saying in this section is that it highlights what is expected to be done when it comes to witness statements. And the governor, I know we have an issue that was expressed about whether the governor should be the one to be the authorizing authority of this particular bill. And that, again, we will discuss in committee stage as who will actually be the authorizing individual or organization. And it states that in section 35B5, deals with the governor may make regulations prescribing the procedures. And it's 35.5A, the taking, handling, and storage of witness statements, the training of police officers in the procedures under paragraph A, which is the taking, handling, and storage of witness statements, and such other matters as are necessary or expedient to give effect in this section. So we're looking at training to ensure that witness statements are taken in the proper manner. Now we go to section 35C, interviews and admissions, and this is again dealing with how they are handled. So in my view, just to say for a minute that yes, our citizens are concerned, yes, everyone is concerned, but I think that it was alluded to before that the bill addresses how things are going to be done. So if we're not following the act when it's passed, and then we go outside of what's in here, then yes, we are violating the rights of our citizens and or even the criminals that are arrested. So again, in my view, these things are being addressed, their concerns are being addressed. And yes, there are some areas that needs to be tweaked a little bit more, and we will be looking into these to ensure, as I said before, there's a balance to ensure safeguarding the rights of our citizens and curtailing the criminal activities in our community. 35C, I will just highlight a few because they have about 10 subclauses in this one, 11 actually. But again, it's to interviews and oral admissions. 35C2, an interview under section 1 shall be also recorded by video recording unless it is not reasonably practical to do so. And I know there's one in particular where it is not reasonably practical to record an interview by video recording, but it is reasonably practicable to record the interview by audio recording. The interview shall be recorded. So there are options, either by video or audio. And, you know, so again, because of modern technology, you're not handwriting statements anymore. You can do so with audio and video to ensure the accuracy of the admission of the statements. And there's the purpose of this section: removable recording medium used in the recording interview shall be new. This one in particular. Any removable recording medium used, and this is 35C6, any removable recording medium used in the recording of an interview shall be new. And then section 7 goes into, for the purpose of this section, removable recording medium includes magnetic tape, optical disc, solid state memory card, or any removable physical recording medium which can be played and copied. In other words, we can use a jump drive to record a statement, but that jump drive must be clean. It must be new so that the information that's gathered is not corrupted with any other information that might be on a used jump drive. So again, I think that the areas are considered and thoughtfulness went into ensuring that, you know, there's no tampering, there's no, there are concerns, yes, but I think the efforts through this bill and the different sections that effort is made to cover as much as possibly could be covered to ensure the concerns of our citizens and everyone else is addressed. And then we have, I will go now into section 38A, and section 38A is the Principal Act, which is, as I said, Police Act Revised Edition of 2013. It is amended by inserting immediately after section 38 the following, which is part 3, Roman numeral 3A, and this deals with special investigative techniques. And this section 38A actually deals with the definitions of the meanings, I should say, or the definitions of interpretations, I should say. So we have stuff that's described or explained in terms of authorizing authority. And the authorizing authority means the commissioner or the senior police officer designed as such. Now, we talked about authorizing authority in other debates that was mentioned, and the fact that who should actually be the authorizing authority to give the permission to do certain things. So again, when we go into committee stage, we can address, should it be the governor, should it be the commissioner, and who should actually be the authorizing authority. And then we have a definition of controlled delivery. It means the technique of allowing illicit or suspect consignments to pass out of, through, or into the territory of one or the more states, with the knowledge and under the supervision of their competent authorities, with a view to the investigation of an offense and the identification of persons involved in the commission of the police. So basically, controlled delivery is, as you see in the movies, a sting. You're setting up something to catch. And then this is where persons are saying it's entrapment. So again, we will be looking at this more closely to ensure that the areas of controlled delivery, and that is under section 38B, and I will go into that it covers also electronic, the interpretation. Before I go into that, interpretation deals with electronic surveillance means, investigating authority, what that means, law enforcement officer, what that means, and senior police officer, etc., etc. So there are definitions, and then there's also an explanation of covert operation and what that actually means. But to go into 38B, the authorization for controlled delivery, and I think this is a lot of concern for persons, and because of the possibility of entrapment, the controlled delivery according to 38B1 is lawful only if it has been authorized in accordance with this part, only if it has been authorized. And the authorizing authority may, on an application by a senior public officer, give written authorization for the controlled delivery to be carried out, and who it has to explain who is actually going to carry out these controlled operations. So not any person could do it. And an application to conduct a controlled delivery shall be made in writing and be specific. And it has to provide all the information regarding the consignment and destination, whether the matter has been the subject of a previous application, and any other additional information. So you're not just overnight deciding you're going to do this. You have to apply, and permission has to be given. You have to explain why you're going to be doing it and who is going to be doing it, and the other specifics to that as well. So conditions for authorization of controlled delivery is covered under 38C, and this authorizing authority shall not approve an application for controlled delivery unless it satisfies on reasonable grounds, and it has 6 items here that you must satisfy in order to get permission for this controlled delivery to be carried out. And it means that a serious offense is being or is likely to be committed. And we talked about a serious offense. We can define that a little bit more to ensure we understand what a serious offense means. It must explain the nature and extent of the suspended criminal activity. Any unlawful activity will be limited to the minimum necessary to achieve the objective. The control delivery will be conducted in a way that ensures, to the greatest extent possible, any illicit goods involved in the controlled delivery will be under the control of the law enforcement officer at the end of the controlled delivery. In other words, if you use something with this controlled delivery, then you have to account for it afterwards. So just to move on in terms of who determines the application. After considering an application, the authorizing authority may authorize a controlled delivery, or it may refuse the application. So there are options. If you don't justify reasonably why you have to have this controlled delivery take place, then the authorizing authority, and again, who is the authorizing authority, will decide, yes, you may proceed because they are satisfied that this information that you submitted, or they may reject it. And then it goes into the revocation and cancellation of authorization, 38E. The authorizing authority may revoke an authorization granted. So there's options again. The treatment of items post-operation, any item 38F, any item imported into the territory in the course of an approved covert operation or controlled delivery when no longer required for the purposes of the due enforcement of this act shall be dealt with as a prohibited and illegal item as provided under the laws of the territory. So again, there are controlling measures. And Madam Speaker, just briefly into covert operations, which is dealt with under authorization of covert operations, 38H. The authorizing authority may unauthorize covert operations for the purpose of A, gathering evidence for serious criminal behavior, or B, the prevention, detection, or investigation of an offense related to money laundering, terrorist financing, or other financial crimes. Now remember, sections 35B and C deals with the mutual evaluations and aspects of 38 as well, of the mutual evaluation reports, because this one in specific, 38HB deals with related to money laundering, terrorist financing, or any other financial crimes. Now, Madam Speaker, I won't go into any further in terms of 38H because there are other sections, as section 2, clause 2, that has subclauses A through E, and clause 3, and there's more into that, but again, we will go into committee stage with that as well. Now, finally, Madam Speaker, I will go a little bit into section 38M, and this too was mentioned during the Leader of Opposition's report or contribution, the reporting obligations. But 38M deals with reporting obligations on special investigative techniques. And 38M says that the authorizing authority shall submit a report annually to the governor in such manner as the governor may determine respecting A, the classes of offenses for which authorizations were given or renewed under this part, and B, the number of authorizations that were approved, refused, revoked, canceled under this part. Now this pertains to investigative techniques. But Madam Speaker, I just want to say that during this symposium, as I mentioned before, and this particular bill was presented, there was a section for reporting under 38F in terms, but it has changed. So I would like to recommend that reporting section go back to the controlled deliveries, because there's no reporting mechanism under controlled deliveries, which is section 38B to 38G. So I am recommending that reporting segment go back, because it will allow for transparency, accountability, when it comes to the number of controlled consignments that took place, how many, again, just like the investigative, the classes of offenses, the number of approved authorizations to have controlled delivery, the refused, the revoked, and the cancelled. So, and then, but however, Madam Speaker, this one says annually. I would therefore recommend the reports be submitted every 6 months, because if you wait until the end of the year to receive this report, then you won't have the opportunity to try to improve. If you receive it at 6 months and you see the trends that are happening, at least you can try to intervene at 6 months so that the latter 6 months you'll have some improvements. So, Madam Speaker, with those said, I will continue to make my contributions in committee stage. And Madam Speaker, I would just want to end by encouraging everyone to take advantage of the opportunity. The opportunity is still there because persons are still concerned and want to see at the end what we will be doing to help to safeguard their rights, their human and constitutional rights. But I believe that the opportunity is still available, that persons can go online, they could find the Police Amendment Bill 2024, they could find the Mutual Evaluation Report, and they could find the Police Act, the Revised Edition 2013, and go through them for themselves. And I encourage you to WhatsApp your representative and let them know that this is your concern. Now, Madam Speaker, when I prepared my contributions for this morning, this was part of my contribution to wrap up. But this morning, I received a WhatsApp message. Well, yesterday I received one, and this morning I received another from a constituent who expressed their concern and about Section 38 of this bill and thought that it was entrapment. So again, there are opportunities still before we go into committee stage that persons can express their concerns to their representatives via WhatsApp, and I'm sure their representatives will take into consideration their concerns and address it during committee stage. With that said, Madam Speaker, I thank you.